guides us, which is what the federal government says we should be doing in child support and how we should be calculating and where we should be. The federal rules are older now, but they are placed in your materials, and then there is a summary letter of kind of the overall dictates from the federal government as to what our role is. So anytime the public brings items to us, we need to make sure we're also still in compliance with the federal needs. The goal is to keep Nevada funded from the federal government for our the money that comes in is for our masters and for our child support enforcement, and there is the overriding gloom of a cloud that says if we don't keep ourselves modernized and in compliance that we could lose that funding. At this time, under the statutes, there is a requirement that the state pursue a audit of our child support statutes every 4 years. We were a little relaxed on this because our last audit is what we started with in 2017, which means we have not had an audit since 2017. However, we did not pass new regulations under the old audit and have them enforceable in the state of Nevada until 2020. Was it February? Committee members? I think it was February of 2020. So the theory was we needed to operate under those new rules for 4 years before a valid audit could be conducted again. That meant that in February of 2024, the state should have started another audit. It is my understanding that DWSS has not started that audit, has not retained somebody to do that audit. And as the chair, I will say that this committee is extremely restricted on compliance with the statutory requirements in front of it without an additional audit. My direction to this committee, with the hope that maybe I won't be on it forever, is that the last audit made a comment that it needed additional statistics for its review, and you'll see in that kind of summary letter that there was a comment regarding review of cases within the state to make for the audit. It's not just review of the statutes, but it's a review of cases and calculations of child support that are happening in the state to determine if appropriate numbers are being ordered and if it's meeting the needs of the citizens. The audit lacked private cases and data from private cases. The reason for that is that we don't have a mechanism for that. We weren't sure how to get that data to the auditor, but we need to consider that, and it will probably be on one of our next agenda items to discuss. Before we move on to the next agenda item, the only other thing I want to say as far as the purview and overview of the committee and our authority and how we run these meetings is that I would like to recommend that we run a motion for doing all of these meetings by Zoom and not having the physical locations in Carson City and Clark County. The reason I believe, one, is I think the public, that's the only way we really get attendance from the public anyways. Two, I think it's fair to the professionals that are on this committee that it is much more fair for you not to have to come to Carson City and Las Vegas to these buildings in order to conduct these meetings. We did do these meetings completely by Zoom through COVID, and it worked just fine, and the systems that are in place are sufficient for that. Do we have any discussion from the committee or thoughts about the possibility of doing a motion such as that? I probably don't need a motion. I have the ability as the chair to dictate how the meetings take place. I just want discussion from the committee really about their thoughts on that and if they want the committee to go that direction or not. You don't want it?
Kathleen Baker for the record. Personally, I only drive from Reno, but it's still a bit of a drive, and it also cuts into the time that I really need to do things at my office. I have had a lot of luck. All of our court hearings are via Zoom. I think I've had a lot of meetings via Zoom. I would agree with the chair that I think we can still accomplish what we need to do via Zoom meetings and avoid the transportation, which is not necessary.
Any additional comments? Sure. Make sure you hit your mic buttons, please. Thank you.
Thank you, Madam Chair. Assemblyman Ken Gray for the record. I'm going to dissent with you. I think having in-person meetings is still very beneficial, and the Zoom option is still there for people that want to participate, but I think having a location in person is still something that needs to be done.
Okay. Additional comment?
Judge Robb, for the record, I generally find personal or in-person meetings to be useful, but in this case, half of our body is in Las Vegas, and so that personal connection is being lost in any event. And so I would be in favor of going to an all Zoom participation agenda.
Assemblywoman Cohen?
Thank you, Chair. I agree. I believe we should be doing these on Zoom. There is access for the public, just as if we had them in person. And we have a lot of professionals attending these meetings that are taking time out of their day to participate. And I think the more we're able to accommodate the committee, the more we're able to have members of the committee participate and attend.
Okay, thank you. Any additional comments?
Madam Chair, Judge Hoskin, and I think certainly I understand the convenience, but as far as in-court kind of things, for me personally, it's so much better to have people in court, and the difficulty we had with some feedback with regard to Ms. Cohen's comments indicates that perhaps some technical difficulties makes things more difficult and more challenging, but I have no problem with the option of people appearing by Zoom, but I think there should be some place that we're actually having a meeting for those people who don't have that kind of technical access to be able to actually come here in person with that option.
Okay, thank you. Any additional comments?
Yes, April Green. I do like the in-person option, and with that, we can still have Zoom as a fairly new member of the team. I don't know who's who except for a couple of people, and it would be nice to be able to put a name with a face and maybe even ask questions, not agenda items, but just get a better idea of who we are and what we're doing by meeting some of the people on the team. Thank you.
Okay, thank you. Any more?
And Madam Chair,
Yes.
this is Sandra Harris. Hi. I think this is largely a very personal question for you because inevitably, if allow a virtual option but also have in person, the chair is the one who would likely have to show up in person while everyone else could be virtual. And so while I also support the idea of allowing people at least to be virtual, whether we continue to have in-person locations, I think is largely going to only require you to be in person as a mandate. I want to throw that out there. The rest of us could always attend virtually where you would likely need to come in person. And so, I think I'd like to hear a little bit more about how much of a burden that might be on you as the chair.
I appreciate that. I think I live in Washoe Valley, so it's not that difficult for me. I did worry because we do have one member from Fallon, but he didn't comment that it wasn't that difficult. So that's what I worry about is the diversity of this committee and ability to get them together. As long as we have both options, I'm okay with it. I do think, since we're under this agenda item still too, I think actually maybe we need to go back to the other agenda item. We probably should appoint a co-chair, somebody as a backup to me so that meetings can happen if something happens to me or I'm unable to make it to the meeting. Otherwise, somebody will just be appointed on the fly. So we can have discussion about that, or you can think about it. And if somebody's willing to be my co-chair, please reach out to me so that I can get it on the agenda appropriately so we can make that happen. Hearing all the comments from everybody, I think the way we are doing it is sufficient. The biggest thing for me is keeping Zoom as an option. So we have had public comment in rural Nevada, in Elko, et cetera, and I want to make sure we continue to receive that comment. Okay.
Madam
Yes.
Chair, may I ask a question?
Yes, ma'am.
Does in-person public comment have to be in the 2 meeting rooms, or can there be another public place for people to show up?
That is a question for broadcast, because I know during legislature they have the ability to do some things in Ely and Elko, but I don't know the answer. I will research that.
And
I would. There may be that possibility in those 2 locations. I don't know of other locations, or I've never heard of other locations during session, at least, but.
For people who couldn't travel from Reno, I think we could make one of the court Zoom rooms available. So although they would have to travel to the court, they wouldn't have to come here. But I don't know if that's a possibility. I'm just raising the issue.
I appreciate that. And as chair, I'll research it with the tech powers of this building and find out the answers so that we can do that. It's dear to my heart that rural Nevada be able to participate in these. So, okay. Any questions or comments about just the overview of this committee and our charge, our specific authority under the statutes?
Madam Chair, if I may.
Yes.
I do have one question. When was the agenda for this meeting posted? I was looking for it online the other day and could not find it, and then I did wind up getting it via email at 4:39 on, it was Wednesday afternoon. So I just want to make sure that we are in compliance with open meeting law, and it was posted in time for everybody.
Yes. So, Joy, if you would, do you have microphone ability over there? Okay. I'm putting you on the spot. Sorry. So everybody understands, I don't have control really over any of the tech end of this. DWSS sets the administrative hearings, is in control of that, and Joy assists us significantly with that. But Joy, when was it posted?
I believe it was posted on Friday, or it was Monday at the latest. I'll have to look to verify for sure, but it was posted in time to be compliant with open meeting law because we posted it before Tuesday at 9 a.m.
Okay. Thank you very much, Joy. There is a struggle, and I will have communication with the staff. I want to be very careful here because Joy, you do an extremely good job for us. Thank you. I do think there is struggles within DWSS, and I have my own comments and frustrations and anger with DWSS about how things are conducted. We have not had a meeting since December of 2022, not because I haven't demanded it. I have demanded and demanded and demanded. This has nothing to do with our administrative staff that's in this room right now. This has to do with the overall DWSS. This committee has a duty to continue to do its job and listen to public comment for review of the child support guidelines. And when I ask for meetings should happen. DWSS says I do not have the ability to demand usage of their resources when I so please. I disagree. Per the statutes, I have a duty, and this committee has a duty, and we need to comply with that duty. And there is a major obstruction between my ability to help this committee comply with those duties and making it happen. And it's a frustration I wanted aired during this meeting because I want it really clear why we haven't had a meeting since December of 2022. Why the recommendations that we gave to DWSS in December of 2022 did have yet to make it to Legislative Commission in order to be adopted, and we will, with that, move on to the next agenda item because I want to it really blends both of our agenda items. But the next agenda item is discussion of the committee's last report to DWSS, which recommendations were and were not accepted. Not all of the recommendations that we made to DWSS made it to the public hearing without any notice to this committee or comment or advice, despite significant amount of time and energy, hearings. This committee can take a lot of time and energy, and that last report is no exception. It was a lot of work for us to get the votes that we received. Now, DWSS has given us a letter with their comments being that they do not have to accept any of our recommendations. And if that's the case, I'm picking my words carefully, perhaps the guidelines need to be removed from the NACs and brought back into NRS by the legislature so that when there is public hearing and there are votes and they are fair votes and things are parsed out and researched, that they are adopted. The recommendations we made in 2022 could have been already law through the session. The point of this committee and why it was adopted at the legislature was for efficiency, to make things happen efficiently, because every 2 years waiting for the legislature was too long for a lot of the needs of Nevada citizens in child support. 2022, December of 2022 to August of 2024, and those recommendations still have not come to fruition by DWSS. You are not meeting the purpose and legislative intent of this committee, which is to make things happen for the state of Nevada without waiting so long. I don't know if anybody else has any other comments about what actually went forward from our report, but does any other committee member have anything they would like to say?
Madam Chair, Judge Ropp, if I...
Yes, ma'am, go ahead.
I didn't say anything when we considered the minutes because I didn't want to be the continual negative voice in the room, but I was dismayed at the timing of the minutes and our receipt of the minutes, for one. That meeting was held more than 18 months ago, yet we didn't get minutes even before the first noticed meeting, which was August 2nd. We got minutes a business day ago. I don't find that to be acceptable, particularly when those minutes reflect things that weren't undertaken or were ignored by DWSS, and I'm trying to pick my words carefully as well. As far as this committee goes, I want to call attention to the makeup of the committee. The legislature very carefully put this committee together, and it is made up of subject matter experts. We have a member of the Supreme Court, 2 presiding judges from the family court in both the 2nd Judicial District and the 8th Judicial District, with a 3rd district judge who doesn't have a family bench being appointed by the Supreme Court. We then have district attorneys from both Clark and Washoe County who are involved in the enforcement of child support. We have subject matter experts who are family law practitioners that are appointed by the Family Law Executive Committee. And one of our subject matter experts has to be knowledgeable about economics and child support guidelines. What you have on this committee, and I'll set myself aside, but what you have on this committee is a group of people who are dedicated to, knowledgeable about, and in the trenches working directly with child support and the guidelines that we are working with, to summarily set aside or ignore recommendations made by this committee after we have listened to public comment, after we have heard from members of the family law, both, I believe, Executive Council and from the Association of Matrimonial Lawyers, who came and testified at length with regard to changes. I think it is disrespectful. I think it is dismissive, and it makes me wonder why this committee exists. If our recommendations are to be wholly ignored, I don't know why we went through the process. The makeup or the composition of this committee is such that I don't believe it was meant by the legislature to be a figurehead, and it certainly wasn't meant by the legislature to simply be the lightning catcher for when there are problems with guidelines, and we are the ones who then take the displeasure from the public. I think there was a reason for us. We have been here and spent many hours, many days, putting together these recommendations, and with considered reasons that were set forth at length in these hearings. I am dismayed and, quite frankly, would not have volunteered to be chair of a committee that I don't believe right now is taken seriously by DWSS at all.
Madam Chair,
Yes.
this is Kirsten Gallagher for the record.
Okay,
So
thank you.
I do have a few things. Nothing was ignored.
Okay, hold on. You were cutting out a little bit, so maybe make sure you're close to wherever your mic is, or... Sorry. Try again.
Is that better?
Yeah, I think
Yep.
so. We just lost a... I just turned my mic off. We lost a word or two, sorry. Go ahead.
Okay. The division ignored nothing. They took all of the recommendations that were given, and the division takes all of this, all of the committee's recommendations, very seriously. However, the administrator in the division cannot accept changes that have a very real chance of causing Nevadans to either need to come on TANF assistance or not be able to get off TANF assistance. The temporary assistance for needy families is a safety net. It's not a program that we solicit for. And all of the divisions, the information was provided in, I want to say, the May 22 meeting, explaining exactly why the division disagreed with that specific recommendation. And I'd also like to add that the division has accepted every recommendation that has been made, save one. And if I might also jump back, I can't tell you about the meeting, the recording, the meeting minutes that are missing or that weren't delivered until yesterday. I can't speak to that. However, if you call for a meeting and there's no state staff, no DWSS staff available to attend because of other things, because we're in the middle of NV Kids certification, that's what's been going on recently. I've tried to be communicative with you, and I'm not sure what else you need. I think the meetings will be easier. It will be able to flow more easily once we're past our certification, which is expected by October, but it's going to be hard until then.
Madam Chair, may I ask for a clarification?
Yes, you may.
Could you tell me which recommendation you think wasn't included? You referenced a May 2022 meeting when the recommendation that I am most interested in was voted on in December of 2022. So we may be thinking of two separate things. Can you tell me what you're talking about?
I'm talking about the very last one that we went over in the public workshop in June. It was, sorry, there's some feedback. It was regarding the halving of the obligation. In the joint scenario.
Okay. Additional comments? I'll make a comment because you stated that the joint physical custody child support calculation will have an effect of putting people on TANF. I think the current mechanism of calculating joint physical custody causes the payors to often need TANF because it's making them unable, or they don't even qualify for TANF because of where their income level is, but the amount of child support going out and their inability to pay their own bills. There was a lot of discussion on this committee about that fairness issue, but basically what we have been told, or what the end calculation and result of everything is that if DWSS disagrees with anything this committee votes on, it will not be accepted. That is the one that you didn't vote on, and thus it didn't go through. So basically, we need to all just turn every time we have a vote and say, DWSS, are you going to agree to this, or are we wasting our time? Now, Ms. Gallagher, I want to be really clear. You were not part of this committee before. I do not want this to be a denigration specifically of Ms. Gallagher at all. This is DWSS. This is your employer that I feel is the problem, the overall entity that you are working for. You were not on this committee. You were not part of those hearings at that time, and I want to be very careful. This is not a personal attack on you at all. And I know you are in the hot seat having to respond right now. And I really thought that your employer was going to send somebody else today because they manipulated the agenda that I put back to just the committee to add themselves on the right-hand column, which meant, in my opinion, they were going to give a specific presentation on these issues today, and they did not. Not you, but DWSS. All right, do we have any other comments? I will say that I want to do some research, and I want to talk to the Attorney General's office about the fact that when I am told that a meeting cannot take place because DWSS is too busy with all the problems within their software. I know of lots of disasters within DWSS right now with child support and the software, but that should not impact the state of Nevada. It should not impact the citizens of the state of Nevada from us continuing to decide what it needs to be done for them. I understand it's busy for you, but I want to determine what can be done so that I can hold a meeting whether you are available or not with your own problems. All right, we'll move on to the
Madam
next.
Chair?
Yes.
Madam Chair, Kirsten Gallagher for the record.
Yes.
So I want to make it clear when I mentioned that we had things going on and state staff need to be available in these forums when we're having our meetings. Joy has to be available. Somebody has to be available from the state here in Las Vegas when we have a room. I'm not suggesting that it's because of any disaster. I'm suggesting that we're going through I'm explaining that we're going through phase 2 federal certification for the NV Kid system, which is not a disaster. It's just very time consuming, and we have limited staff. That doesn't mean meetings have to stop. That just means it's going to be difficult to coordinate. It's going to be more difficult than it was back when the committee started to coordinate these meetings. Thank you.
Okay, thank you. Any other comments from the committee before we move on to the next agenda item?
Madam Chair, Judge Hoskin, if I could.
Yes, please.
Is there, All right, I have received no information since our last meeting in December of 2022, which wasn't unusual in my mind because the last time when we promulgated these originally, I didn't receive a lot of information until it was finally promulgated. But my understanding is that it was moving forward, and now I'm learning in the last few days that really nothing has happened since then as far as these rules moving forward. Are they in contact with you as the chair with updates and we're not included in that, or is there simply no communication? I'm trying to come up with a way to make this work better and some suggestions for perhaps improving it if this is the problem we're running into, and I'm not sure that I fully understand it. If you could clarify.
Yes. For the most part, no, they are not in communication with me. There's a significant number of emails of me pushing for communications and understanding of what's moving forward and being told it's just moving forward. I cannot turn around and send an email out to the entire committee with an update of what's going on because that's a violation of public meeting laws. Thus, I have to have a meeting to give you guys any updates on what's going on or for them to give us any updates as a conglomerate, as a total committee. And so that's part of the frustration is that I demand a meeting and it's, well, we're going to get these going, we're getting them going, and nothing's happening. They finally did hold one public hearing on the amendments from December of 2022. That was held in, when was that held? June? July? June. I was the only one there for public comment to express my displeasure that it was not the complete recommendations from the committee. But like I said, I send out an email saying we didn't have a quorum from the last meeting, and I literally had heartburn whether or not that was a violation. But there was no business conducted, so I felt okay with it. But that's how anxious I have to get about public meeting rules. And the Attorney General's office, watches that carefully, which they should, and that's appropriate. And we do want this being done in front of the public. But we, at times, need to be able to hold even just a 30-minute meeting by Zoom, if necessary, for those kind of updates, because I can't just send them out. But that's the struggle. That public meeting should lead to them submitting their version of the amendments that we last passed to Legislative Commission for them to review so that it becomes NACS. So there will be another hearing conducted, but by the legislature this time. I have no updates and no information unless Ms. Gallagher has information on where that's sitting based on the last public hearing that was held on it.
I do.
Okay, thank you.
The public hearing, so the workshop was in June. The public hearing, I believe, is scheduled for someday in September. And I can't tell you what it is off the top of my head. However, if we need to start sharing communications about like the process of where everything is so that you don't have to worry about whether or not you're violating open meeting law, we can start doing that. We should start doing that.
Thank you. It should happen. And the public should know what's going on. I get as chair a lot of comments from the private bar especially saying, what the heck is going on? And I have no ability to respond other than we're trying to hold another meeting. Sorry, there won't be one. I don't know when there will be one. So now that we have this hearing, my hope is we get the next hearing on the calendar and we get some consistency going and we know that we're going to meet once every so often. At the end of the agenda, we have the ability to talk about future agenda items and then next meeting date, and we will do so under that agenda item. But yes, those updates do need to be happening, and this committee does need to know what's going on. Any other comments on this agenda item? Okay. Hearing none, we'll move on to the next agenda item. Discussion of concern voiced by Nevada's low-income legal service providers regarding the court's obligation to consider the reasonable cost of child care paid by either or both parties and make an equitable division thereof pursuant to NAC 425.130. When we had our original meeting date that we did not have a quorum for, legal services was going to testify on this bill. Based on this date, they were unable to be here to testify on this issue. I don't know if Ms. Green has any input on this or not, but the concern that was expressed to me for the committee to take into consideration isn't the issue of the court considering the child care costs. It's the issue of the findings, the detailed requirements that we had in our recommendation for findings of facts on that, and the concern that those who are self-represented will have a difficult time complying with that requirement or providing the court with sufficient information for the detailed findings of fact. Now, I do think this is an issue that is very different for Southern Nevada versus Northern Nevada and the methods being used for drafting of court orders in these matters. So I don't know if anybody has any additional information or would like to discuss this, or we can table this agenda item for our next committee meeting so that we actually get legal services here to express their real concern and not Kim's hearsay version of what their concern was on it. Any other comments?
April Green, I
Thank
don't know anything about this. Legal aid in the North has not approached us, and maybe because of the open meeting laws, to discuss this with me or tell me about it. So I would prefer we table it and let.
Okay, to be clear, it was Southern Nevada Legal Services that expressed the concern. So I'm happy to table this agenda item. I don't know that we're doing anything substantive today anyways, because we have so many new committee members that need to get up to par on where we're at. I just want to set the table for where the next agenda is going to go and what the issues are. This is a good example, though, just to be clear, that when the public has concerns or practitioners in the state have concerns about the feasibility of the statutes and how they're written, that they just need to reach out to me as the chair, or we have other mechanisms on the agenda for reaching out so that we can get items onto the agenda for consideration. All right, the next agenda item shows that I lied earlier in the meeting. I didn't lie, but I made a mistake. It is on the agenda. Discussion of public concern expressed to the chair regarding the need for the committee to consider the use of income tax deductions and income distribution among the parties in child support matters. So I did put it on the agenda. But as chair, I will comment that this committee did consider this at one point in a hearing because somebody else had brought it to us. We went through great detail as to what our duties are and what within the statutes we have control over, and a decision was made that we did not have control over this issue. My recommendation for the public is that we do have legislators on this committee, and we not that they have lots of bill drafts ready to go and still available by any means, but they like, I was speaking for them, I think they like to hear from the public as to needs and concerns for edits and changes to the NRSs. The Nevada revised statutes are not within our purview, just the Nevada Administrative Code chapter regarding calculation of child support, so we cannot do anything with that. Does anybody on the committee have any additional comment on that? Okay. Hearing none.
I do.
Oh, we do?
I do.
Oh, sorry, Ms. Cohen. I just can't tell when you have your hand raised. I apologize. Thank you.
That's okay. And just so we're all clear, so that anyone listening is all clear, that requests to legislators for bill drafts do not need to go to members of this committee. They can go to any legislator. They can also go to the legislative committees directly. I'm sure the chairs of judiciary would be thrilled to know that I'm putting that out there, but they can also go because the committees do have their own bill draft requests as well. Or again, any legislator, not just members of this committee.
And just for a little bit of public education, right now is really late because it's really close to session. So it doesn't mean something will happen this session for you, but that's not necessarily true. There may be some new members of the legislature elected coming up and who are fresh and are willing to listen to new ideas. We highly recommend that everybody participate in this process, both through this committee and through the legislature. It's necessary for us to get to what is fair. My soapbox on this is that there are very few people lobbying on behalf of just regular old everyday family law statutes at our session, and it takes public coming to legislators oftentimes to identify issues that need to be resolved. All right. Any other comments? Hearing none, we will move on to the next agenda item, which is discussion of whether the Nevada Supreme Court's holding in the case, I can't ever say it, McClellan, right? Versus McClellan? Oh, see, I was way off. Versus Davis, allows courts to exceed the authority to adjust an obligor's base child support obligation under Factor F of NAC 425.150, subsection 1. Again, this is another agenda item that we had somebody lined up to testify on, the individual who brought this issue to me as the committee chair, until we didn't have a quorum and we had a new date, and then that attorney was no longer able to be here. So we don't have the testimony today. We did, I don't know, did the case, I don't think, made it as an exhibit, but my goal would be to table this, make sure that for the next agenda the case is attached, and we do have somebody here to testify, but I don't know if we have any of the judges or other attorneys that have any comments that they want to make before we address this. But this is just a matter of when issues are brought to me, I don't try to decipher. The only filter I use for whether it goes on the agenda or not is if we've already addressed it, I'm not going to waste the committee's time. If to the best of my knowledge I can remember if we addressed the issue or not, and two, whether it's within our purview to even address it. Otherwise, it's my duty to make sure everybody has a fair opportunity to bring issues to the committee. Do we have any other comments on that agenda item number 9?
Madam Chair, Judge Hoskin?
Yes, please.
Yeah, I think that on our last meeting, this was one of the issues I raised for future because it had come down fairly recently at that point. And the issue that I think is within our purview is the Supreme Court specifically references NAC 425-151F and essentially indicates that we intended that there was a cap. And the concern that I had when everybody was calling me after I had told them at several conferences that there was no such thing as a cap anymore, that we probably needed to do some clarification. So I'm okay with tabling this, but just so everybody understands what the issue is, I think it's more of a clarification on our intent from previous committees, previous versions of the committee, I probably should say, in order to clarify. And if this was our intent, what the Supreme Court has interpreted, we just need to make that determination. It's just not my belief that that is what we intended for that regulation to mean.
Okay. Additional comments from the committee? My comment would be that it is my interpretation of our previous renditions of this committee, as you put it, that we do not have a cap. That was one of the items specifically noted in the pages and pages from the federal government that we really shouldn't have any caps, and that our prior caps were a violation of our duties under the federal rules as far as taking each family into consideration and their needs, and that not all families are the same, and that at times there are children and needs of a family that we don't know what those numbers are going to be. So we shouldn't dictate a cap and set it at anything specific, because we need the judges to have that discretion to come to the right numbers for a family. Judge Robb, I see you about to push your button.
Thank you, Madam Chair. We may not call it a cap, but there is certainly a limitation. And it was a limitation that was negotiated and voted on. So there is a limitation there. I will note, too, my recollection, and Judge Hoskin can correct me, but the Nevada Supreme Court also stated that child care and extracurricular activities are not per se child support. They saw them as being something above and beyond base child support. And so that was, I think, a nuance that was part of that case as well.
That interpretation concerns me, because part of the dictate to us by the federal government is that child care and health insurance should be part of the calculation. It was part of the reason why we reorganized the statutes some last time, because we wanted to make it clear. It's really hard to make this clear within the statutes somehow, that that's why we started calling it base support, right? Because it's not, the support number is the total at the end. The base support is the starting point. So that meant everything in between is part of child support. It's just whatever you calculate at the end. So the child care and health insurance requirements or health needs of the child were dictated to us to have to be part of the calculation. So does it cap? Well, I guess we do need more discussion on this, on that whole wording of limitation versus cap. We didn't use either of those words in the NACs themselves or our recommendations, but it's the effect. Except that it's supposed to be adjustable, because new committee members, you probably think this is psychotic, because I'm about to say we can't use the word deviation anymore, and we didn't use it intentionally so that we didn't get in trouble with the feds, yet we can adjust but not deviate. And what the heck are those semantics? And is it a cap? No, it's a limitation. It's not a cap. We sound ridiculous at times, and unfortunately that's what we had to go through for this committee for where we're at. New committee members are probably thinking, what did I sign up for right now?
Oh, you thought we signed up.
Oh, I thought you signed up. You're right. Voluntold. Maybe we do need more discussion on this issue. And I know Judge Robb finished her comment with, Judge Hoskin can correct her. This is the way this committee goes sometimes between those two. And I don't know if Judge Hoskin, if you have any additional input right now.
Am I being voluntold?
You're being voluntold, because that's the best part about being chair right now.
I don't. And you're selling the position there, Chair. All right. The only comment I have is that I don't know if what we're doing is spinning into more semantics, because the section in the regulations, and you kept saying statutes, Madam Chair, and I know you meant regulations. I just want to make sure that
Thank
is
you.
clear.
Yes.
We're not adjusting the statute. But in the regulation, it says, so long as the adjustment does not exceed the total obligation of the other party. Now, is that a limitation? Yeah, I think it probably is. Is it a cap? And maybe it's just that I'm sensitive to the word cap. But the way that the Supreme Court interpreted it, in my humble opinion, is contrary to the hours and hours of discussion we had on this very issue and all the instruction that I gave to the State Bar on several presentations. So if I'm wrong, I would like the committee to tell me that I'm wrong, and I can clarify that at future presentations. But in my mind, I do think we need to go back and take a look at this just to make sure that what we intended to have happen is what we're instructing to have happen in the future. So I don't know if that's a correction of Judge Robb or an agreement with her, but that's kind of how our conversations go anyway.
I think some of the issue too comes from, well, when you start with, I guess when you back yourself up to the base compensation, income levels mean that our starting base compensation is not limited. I'm trying to pick the words now. Is not capped. And that's a big difference from our prior version of child support statutes by leaps and bounds. And the prior directive that we had from Supreme Court case law based on the old statutes was always slap our hands, us being practitioners or judges, for deviating too much or going off of those amounts, which meant there really was a very definitive cap. And we really wanted to get away from that, and we were told to get away from that by the feds because of, again, the needs of families, and but ability to pay is always that overreaching thing that we have to stick to. And we've struggled with that language about not to exceed the obligor space, or not, what was the language? Not to exceed, their child support obligation. And we struggled with those word choices, and I'm not sure we were convinced. It met the needs of what this community needed at that moment, but we knew there was going to need to be some practice under it and some feedback as to how it played out in real life within the community. And that's the case with all of everything we've passed. And, to even talk about the child care part of it that legal services brought to us as an issue, that hasn't even been passed yet. That's part of what needs to keep moving forward in this next hearing from DWSS. We don't even have any practice under it to know if it's an issue yet, to know if we caused the problem or not necessarily. But I would say to the public, we'll keep this on the agenda, and I do believe there are a couple of practitioners that want to come, private practitioners that want to come forward and talk about its actual application in real life. That is what this committee needs from the public, in my opinion. We need to hear real cases, real calculations, real examples of what has happened in cases, so we know how it's actually playing out, and if we need to deviate the language. No, I'm just kidding. Change the language in the NACs, but we need to know real life scenarios, and I can't emphasize that enough. There's probably not enough people listening to our hearing to care, unfortunately. A lot more need to care, but if you're listening, we need you to come to us with real cases and real scenarios so that we can hear how it's playing out. Any other comments?
So we're tabling it, by the way. We're
Yes.
tabling this for another, okay.
We will keep this on the agenda. I will table it and move it, and then with hopes of gathering some people that can speak to us on this issue. So our next agenda item is discussion and approval of ideas for future agenda items and the next meeting date and time. So do we have any other items that the committee is aware of that we need to review and assess at this time and put on the agenda?
Madam Chair, Adam Hughes.
Yes, please.
So as for a future agenda item, I'd like the committee to consider whether we need to clarify or provide interpretation of the low-income payer table. So the committee last go around adopted this low-income payer table, and there's three columns when you determine how many children are in a case. If there's one child, there's three columns you need to look at. It's monthly income up to, and then percent and child support amount. So there's been some discrepancies between courtrooms as to what number we're looking at on the low-income chart. So I've got the old chart from 2022 in front of me, and it says for monthly income up to $849. So the question is then, is that a band of zero income to $849? Or do we need to determine the actual gross monthly income of the party? And then once we do that, do we apply the percent or do we apply the child support amount? So I'd like to propose that as an agenda item for the committee.
Excellent idea. Thank you. That's exactly what we need. is exact specific items like that so we can consider it. I will make sure that makes it onto the agenda. I appreciate that. And hopefully you'll be able to do some presenting on it when it's on the agenda for the next meeting. That's that voluntold stuff. All right, any other items? Okay, if any of the committee members hear of complaints because people find out that you were on the committee and they have things they want changed, direct them to submit specifically what their issue is, maybe some exhibits hopefully with it, and willingness to show up to talk to us about the issue, unless it's general public who is uncomfortable with that. But and then make sure I know of the items so that it makes it onto the agenda, please. Okay, how often do we want to meet? I don't know that monthly's a little crazy when we don't have a full agenda, obviously. And we need enough notice to make it easy to get us the right people in front of us for these agenda items. So I'm thinking 2 months out. Is there objection to that, or is that reasonable, or do we need it more often than that? Thoughts? Anybody?
I think 2 months is great.
Kathleen Baker, I would agree with that, and if for some reason we start getting more issues, we can meet more frequently.
Okay. Yes.
I think 2 months is good. I would just say October that would put us in October, and there is a problem in October because the end of the month is Nevada Day, and then there are Jewish holidays leading up to most of that month. So just please be careful in October.
Okay. Thank you. I appreciate that.
April Green?
I may fluff it with a
Madam
month
Chair?
and a half or whatever I need to do to make that work. Yeah, Miss Green, did you just comment?
I would just suggest quarterly.
Quarterly?
Yes.
Madam Chair, that was
Yes.
going to be my suggestion as well, and that would put us into November, prior to the holidays, post-election, post-October holidays.
Good suggestion. Solid suggestion. All right, especially for this committee and this building. Okay. I will aim for November and get notice out immediately. I want notice to go to, we'll make sure that the family law section gets it out there to all the private bar. I want more notice of these meetings. Part of that will require that once you receive something from Joy, which will hopefully we will make happen right away, that which just takes coordination with LCB so that we get what we need for that, that the committee also take it on their as their own duty and obligation to get it to anybody that you have that needs notice, meaning if you have any other resources for posting and notice, that you please do so within your communities or whatever mechanism you have. That probably sounds as vague as possible, but when the very, very first meeting we had with this committee, a big part of the meeting was about how are we going to make sure people know about us so that we get that input. And for a while we had good public input, and we've lacked it for a little while, and so we kind of need to rejuvenate that so that we get some confidence in the public. There's nothing better than getting the public comment to our meetings. All right, so I will aim for early November so that we're not in conflict with Thanksgiving, and but watch the election timeline, and we will hopefully get information out right away. I will post a agenda pretty quick, keeping in mind I try to keep it a little bit open so if other items need to be added, but I don't think there's any rule against me amending the agenda as we get closer if we need to. All right. With that, do we have anything else before I move on?
Yes,
Yes.
this is Kirsten Gallagher for the record.
Yes, Ms. Gallagher.
You were talking pretty fast at the beginning of the meeting and blew past talking about hiring the economist, so I wanted to give you an update. I know you and I had discussed it, and I do agree that
Just real quick, hold on. Let's make sure we go to, because I need to reopen the agenda item just so I don't get AG trouble here. We would call this under probably agenda item number 5, because that's the authority and DWSS's administrator's directive. Okay, so we'll reopen agenda item number 5. I'm sorry, Ms. Gallagher, go ahead. I just want to make sure I'm properly doing what I need to.
Thank you. So you and I had discussed this, and I do agree that this is a really good time to get The Economist back on board now that the guidelines that were overhauled have been in place for a while. I am working with our contracts team to do that. It has to go out to RFP, so it's a bit of a process, but that has already been started.
Okay, perfect. I appreciate that update. And just,
Madam Chair, could I
Yes.
ask for a clarification?
please.
You indicated that the process has started. Does that mean that the RFP's already gone out? And when is the close date on that?
The RFP has not gone out yet. That the process of getting the RFP to the point where it goes out has been started. And I do not actually have any idea how long or really what that entails. I do not know how long the process is.
Okay, it will, so everybody,
One more thing.
yes,
Oh,
go ahead.
sorry. Well, it is a good recommendation to hire an economist. It is not, in fact, federal law. It would, I say that obviously make all of our lives much easier, but there are many states that do not hire an economist, and I did verify. Although I agree that we should do this, I did verify with my federal representatives that we were not in violation of a law with not hiring if we did not hire an economist.
Madam Chair, just I want to get a clarification real quick on the comments that were made just prior. So you don't know how long the RFP process will take. You don't know how long, or what the process entails. But the process has started. So where does that actually put us? What is started? I mean, just please clarify what has been done with regards to the process so far.
The process that's been started is me working with the contracts team, and I fill out a lot of paperwork and give them information, and this is the first RFP I've done, so I'm not really well versed on all of the steps that need to happen. My contracts team is leading me through it.
Can I clarify when you met with them?
Last month.
Thank you.
Okay, please do, Ms. Crecilius.
Okay, so I work at a DHHS agency, so in the same department as welfare, but a different division. And when we do the RFP process, the whole process takes about 6 months. So it starts out with filing the paperwork, coming up with what you're asking for, putting together a scope of work, and then at some point, depending on the dollar amount, you need to interact with the purchasing division at a different department. And then it gets posted, and it's posted for a certain time. There's comment period back and forth. Then you get the proposals and you review them. So that whole process, we find, at least in our division, takes about 6 months. So I don't know if that's helpful, but just another feedback on that.
All right, I would comment that I highly encourage you to not just consider whether it's a violation of the federal rules, but what your duties are under the NRSs that establish the committee and establish that every 4 years the audit was to take place. So I would agree that an economist isn't always practical. I will tell you, the first time we ran this audit, I participated with trying to establish who was going to do the audit and speaking to the person. There are very few individuals in the country that are experts enough to come in and do this work and audit our statutes. They're not just auditing our statutes, but the way the feds made it, they made it where there's a limited number of people available. Because they got to review cases and our statutes, the outcomes, and make a determination. Then, if along with the federal rules, and there's not very many people that meet that need. I'd be surprised when you put the RFP out there if you get too many people that can even do it. But it's not just that it's a good idea that it be done right now; it's that it's late, and it's not been done. The last time, when we did our child support guidelines in the 80s, up to when this committee finally made its first changes, what the state was skating on and not having these audits done was the fact that we had brackets that the Supreme Court reviewed those brackets in the amounts of child support yearly and put new amounts in based on the economy. And it was determined, and when in speaking to the auditor, that was really not compliance with what the requirements were under the federal rules, but that's what we had been surviving on. So when we had this audit done, it was the first time it had been done since the 80s. And the reason this committee was established was because we had not had significant changes to our child support statute since the 80s. And we were way behind on doing what was needed for the state of Nevada. So I just would tell you, I don't know, Ms. Gallagher, I feel bad because you weren't part of any of the beginnings of this. So you are learning this by trial and fire in the typical fashion that state government throws employees into new endeavors. But that there are statutes dictating what needs to be done, and it was adopted within that bill, and that bill was attached to the exhibits for this meeting today.
Madam Chair?
Yes.
For the next meeting, can I specifically request that we get an update on where the RFP stands?
Yes, I will add that to the agenda.
Thank you.
Okay, any other agenda items? Okay, hearing none, I will move to our last agenda item, which is agenda item number 11, general public comment. If we may please start with anybody on the phones for public comment.
Thank you. If you would like to participate in public comment, please press raise hand in your Zoom window. Chair, you have no one wishing to participate at this time.
Okay, thank you. Is there anybody in Las Vegas that would like to participate in public comment? Seeing none, anybody in Carson City that would like to participate in public comment? Seeing none. All right, thank you. We'll move for adjournment of this meeting, and again, we'll aim for beginning of November. November for the meeting, and I will get you dates and see you next time. I appreciate everybody's time today. Thank you.
Thank you.